Lawyers are not supposed to file groundless lawsuits. When they do, the worst that usually happens is the case gets dismissed and the losing side has to pay court costs. Now, in rare instances, though, when a civil action is frivolous enough or filed in sufficiently bad faith or under false premises, the court can sanction the attorneys involved. Well, today, Sidney Powell, Lynn Wood, and other lawyers who sued to get election results thrown out in Michigan faced a federal judge. By most accounts, it did not go well for them.
Tonight, a powerful, unsealed order from a federal judge reveals a disturbing priority within the Justice Department. We go inside the secret emails where top officials labeled the prosecution of a single man a top priority only after he won a major victory against the administration. Is the legal system being used for the law or for something else entirely? We have the full story.
Due diligence. How do you think today's hearing went?
Well, it was 6 hours, so it certainly was. It was a very educational experience, I think, for a lot of folks who watched it. It shows that there is a lot of due diligence happening with regards to this question before the court. Should there be consequences for when attorneys who use their privilege and access to the court to try to undermine democracy with no facts, frivolous claims, with one goal of sowing seeds of doubt among the public about the integrity of our election?
There is a concept in American law that is supposed to be a shield for every citizen. It is called due process. It is the idea that the government cannot just decide it does not like you and use the massive power of the police and the prosecutors to crush you. It means the law has to be fair. It means the government cannot be vindictive. But tonight we have new evidence that suggests that SHIELD might be cracking. We have an unsealed order from a federal judge that takes us behind the curtain of the Department of Justice. The story begins with a man named Kilmar Abrego Garcia. He is a Maryland man who found himself caught in the middle of a national flashpoint over immigration. He was sent to a notorious mega prison in El Salvador as part of a crackdown on immigration. But here's the thing, a judge had already ruled that he should not be sent there. That judge found that he would likely face torture and persecution by gangs in El Salvador. Despite that, he was removed anyway. He fought back. He took the government to court in Maryland, and he won. The court ordered the government to bring him back to the United States. That should have been the end of the story. A citizen or a resident asserts their rights, a judge agrees, and the government follows the rules. But according to new documents, the moment Mr. Abrego Garcia won that victory, he became a target. As soon as he was returned to the U.S., the Department of Justice hit him with criminal charges for immigrant smuggling in Tennessee. The DOJ claimed this was based on a traffic stop that happened 3 years ago. Judge Waverly Crenshaw is the federal judge looking at this case in Nashville. He just unsealed an order that is frankly stunning. It shows that top DOJ officials only started talking about these charges after the Maryland ruling went against the administration. And it gets more specific. One of the key aides to Deputy Attorney General Todd Blanche, a man named Akash Singh, sent an email to federal prosecutors. In that email, he said that bringing this smuggling case against Mr. Abrego Garcia was a top priority for the department. Think about that. Out of all the crimes in America, all the major cases the DOJ handles, a 3-year-old traffic stop for one man becomes a top priority the moment he wins a court case against the government. Judge Crenshaw noted that these documents might contradict what the government told the court earlier. The DOJ had claimed the decision to charge him was made locally in Tennessee without any outside influence. But the judge says the records suggest it was a joint decision involving the high command at the DOJ. The judge found a realistic likelihood that the charges were sought for vindictive reasons. He pointed to an interview where Todd Blanche admitted the government only started investigating this man after the judge ruled against the administration's authority to remove him. The sources show that Abrego Garcia is now entitled to a hearing to prove his case should be dismissed because of this vindictive and selective prosecution. This is not just about one man. It is a look at how the machinery of the law can be turned into a weapon of retaliation when the government loses a fair fight in court. This case of Kilmar Abrego Garcia is part of a much larger pattern we are seeing in courtrooms across the country. For years, the legal strategy around Donald Trump has been described as a shield. His lawyers would file motions, use delays, and challenge every authority to keep the cases from moving forward. But lately, that shield has started to experience a slow-motion collapse. The sources describe a systematic judicial crackdown. Judges are no longer playing along with the delays or the games. We are seeing federal judges take the extraordinary step of piercing attorney-client privilege. Usually what you tell your lawyer is a secret. The government can't see it, but there is something called the crime fraud exception. If a judge believes a lawyer's advice was used to help commit a crime, that secret is gone. In March 2023, a federal judge ordered Trump's attorney, Evan Corcoran, to testify before a grand jury about his private conversations with the former president. This was about the classified documents case at Mar-a-Lago. The judge looked at the evidence and decided that something illegal might have happened, and the lawyer had to talk. Corcoran had to tell a grand jury what Trump told him and what he told Trump regarding those boxes of sensitive records. This changes everything for a legal team. When a lawyer faces personal legal risk, when they might go to jail or lose their license for protecting a client, some of them start to crack. They flip, they cooperate, they distance themselves. We have seen entire legal teams resign in the middle of cases because the personal risk became too high. This is happening in multiple jurisdictions. In New York, Judge Arthur Engoron grew heated during the fraud trial. He accused Trump's legal team of enabling their clients' attacks on court staff and playing games with discovery. He fined Trump personally and made it clear that jail time was a real possibility if the behavior didn't stop. The sources tell us that the admits everything headlines you see on social media are often clickbait, but the reality underneath is just as serious. It isn't one explosive moment where a lawyer confesses to a crime. It is a series of losses where judges find that the lawyers are pushing boundaries too far. It is the judicial system saying the line is here, and if you cross it, you will face consequences. We have to look at what has happened to the lawyers who chose to push those boundaries the furthest. People like Sidney Powell and Lynn Wood. They were the ones filing the Kraken lawsuits after the 2020 election. They made wild claims about rigged voting machines and foreign software changing votes. In August 2021, a federal judge in Michigan dealt with one of those lawsuits. It did not go well for them. The judge called their lawsuit a historic and profound abuse of the judicial process. These are not words a judge uses lightly. It was a formal declaration that these lawyers had used the court system to push a political agenda without having any real evidence. The consequences were real. The judge ordered 9 of these lawyers to pay the legal fees for the people they sued, likely hundreds of thousands of dollars. But even more humiliatingly, the judge ordered them to go back to school. He required them to take 12 hours of continuing legal education specifically on ethics. It was the judicial equivalent of being sent to the principal's office and told you don't know how to do your job honestly. Since then, we have seen a wave of disbarments and license suspensions. Rudy Giuliani had his license suspended in New York and D.C. Jenna Ellis took a deal in Colorado where she admitted to making false statements. John Eastman was disbarred in California. Lynn Wood eventually gave up his law license in Georgia rather than face more discipline. The sources explain that this has created a downward spiral for Donald Trump's legal defense. Serious lawyers at major firms are watching what happened to these people. They see the sanctions, the public shaming, and the loss of licenses, and they decide they won't take the risk. They don't want to defend increasingly aggressive legal positions if it means losing their careers. This leaves the former president with lawyers who are either true believers or lawyers who don't have better options. And when the quality of lawyering goes down, the losses in court tend to go up. Now that Donald Trump has returned to the White House, the legal battles haven't stopped. They have shifted. The sources describe a second-term legal landscape that is defined by turmoil and constant litigation. In just the first 2 months of his new administration, 127 lawsuits were filed against the government. Scholars say many of his early actions have ignored or violated federal laws and the Constitution. One of the most visible examples of this turmoil is the case of Alina Habba. She was one of the former president's personal lawyers. He tried to appoint her as the interim U.S. attorney for New Jersey. This is a massive job. U.S. attorneys are the top federal prosecutors in their states. They are supposed to be symbols of ethical and professional lawyering. But a federal judge, Matthew Brann, recently ruled that her appointment was unlawful. The judge found that her term had actually expired in July, and the administration's efforts to keep her in the role through unconventional maneuvers violated federal law. He even warned that actions she took after July 1st might be void. This has left federal cases in New Jersey in a state of limbo. Plea hearings and sentencings were canceled because no one was sure if the prosecutor had the legal authority to be there. This isn't just a procedural fight. It strikes at the heart of executive power. The administration claims the president has broad authority to make these temporary appointments without Senate confirmation. But the courts are increasingly saying that there are limits. We are also seeing the administration target law firms it views as political enemies. This is something legal experts call unprecedented. President Trump signed executive orders targeting firms like Perkins Coie and WilmerHale. These firms had represented his political opponents or were involved in the Mueller investigation. The administration tried to bar them from government contracts and even suspended security clearances for their employees. Federal judges have been striking these orders down. One judge found that the order against Perkins Coie was an attack on the foundational principles of the American legal system. Another judge ruled that the targeting of WilmerHale and Jenner and Block violated the First Amendment. The courts are acting as a wall, telling the executive branch it cannot use the power of the government to put its political opponents out of business. But while the courts are fighting these battles, something is happening in the public square. There is a deep and growing crisis of trust in our institutions. We can see this in the way people are reacting to news about political violence and federal investigations. The sources take us into a discussion on Reddit about a very serious event, an assassination attempt on a political figure, Charlie Kirk. This wasn't just a news story, it became a debate about whether anything the government says can be trusted. People were looking at text messages released by the FBI that were supposed to be from the suspect. The debate was fascinating because it wasn't just about the facts of the case. It was about vibes and authenticity. A lot of younger people, Gen Z, were looking at these texts and saying they sounded fake. They argued the suspect used cop speak or boomer speak instead of how a 22-year-old actually talks. They pointed to terms like squad car or my vehicle instead of cop car or my car. They thought the messages were too convenient for the prosecutors, like they were a checklist of evidence to tie up every loose end. Now, some people argued there were logical reasons for this. Maybe the suspect grew up in a police family and picked up the lingo. Maybe he was trying to sound serious because he was doing something extreme. But the most important thing wasn't whether the texts were real or not. It was the fact that so many people assumed they were fake because they no longer trust the FBI. One commenter put it perfectly. They said the ultimate sin of the current political era is that it has destroyed any trust that our institutions won't constantly lie to us. When people see the FBI director testify to Congress about sensitive cases and they believe he is lying, they stop believing anything the agency produces. This is the environment the courts are operating in now. It is a world where every piece of evidence is viewed through a political lens. It is a world where people are skeptical of everything. And that makes the job of the judges even harder. If the public doesn't trust the evidence and the government is seen as vindictive, the entire foundation of the rule of law begins to shake. We should also talk about where the original criminal cases against Donald Trump stand. Back in 2023, there were 4 major indictments. 2 were state charges and 2 were federal. He was convicted in New York on 34 counts of falsifying business records related to payments to Stormy Daniels. But on January 10th, 2025, the judge in that case issued an unconditional discharge of his sentence. The other cases have mostly dissolved. The federal cases, one in Florida about classified documents and one in D.C. about the 2020 election, were both dismissed. Judge Aileen Cannon dismissed the Florida case, ruling that the appointment of special counsel Jack Smith was unconstitutional. After Trump won the 2024 election, the Justice Department chose to wind these cases down anyway, because their long-standing policy is not to prosecute a sitting president. In Georgia, the case was paused for months while the court decided whether to disqualify the prosecutor, Fani Willis. Eventually, a new prosecutor took over and dropped all the charges in November 2025. He said he simply could not find another prosecutor willing to take the case. The Supreme Court also played a massive role here. On July 1st, 2024, they ruled 6-3 that a president has immunity for official acts committed while in office. This ruling effectively ended many of the legal challenges related to his first term. So, while the original indictments are largely gone, they have been replaced by a new wave of legal battles over the actions of the second presidency. The sources tell us that the walls closing in narrative we heard for years didn't lead to a dramatic climax. Instead, it led to a long, slow process of appeals and dismissals, and now a new set of conflicts between the White House and the judiciary. One of the newest and most intense legal fronts is the Department of Government Efficiency, or DOJ. This is the agency led by Elon Musk that is supposed to cut government spending. But the sources show that DOJ is facing dozens of lawsuits from federal employee unions and state governments. The main issue is data privacy. The administration has been granting DOJ staffers access to sensitive financial and personnel records. Unions are suing, saying this violates the Privacy Act because these are private individuals, not confirmed government officials, looking at sensitive data. In some cases, judges have blocked this access. A judge in New York issued an injunction barring the Treasury Department from giving DOJ access to their financial systems. Other judges have issued similar orders regarding personnel records and student financial data. There are also lawsuits challenging the very existence of DOJ. 14 states filed a lawsuit arguing that Elon Musk is performing governmental duties without being nominated by the president or confirmed by the Senate. They say this violates the Appointments Clause of the Constitution. The administration has been defying these court orders in many cases. A Washington Post analysis found that the administration has defied or frustrated court oversight in about 1/3 of all the lawsuits filed against it. Legal experts say this pattern is unprecedented and could lead to a constitutional crisis. When the executive branch simply decides it doesn't have to follow a judge's order, the entire system of checks and balances stops working. This defiance is leading to something we haven't seen in a very long time: the threat of criminal contempt for government lawyers. In several cases, federal judges have found probable cause that administration officials broke the law by ignoring court orders. Specifically, there are cases where judges told the government to stop certain deportations, but the government allegedly did them anyway. Now, individual lawyers from the Department of Justice and the Department of Homeland Security are being forced to testify under oath. The judges want to know, did you know about the order? Did you tell your clients to ignore it? Did you lie to the court? Criminal contempt is a big deal. It isn't just a fine or a slap on the wrist. It can lead to jail time. We are now in a situation where the relationship between the judges and the government lawyers has broken down. Usually, there is a level of mutual respect. But now, judges assume the government might be lying to them. They are threatening to send government lawyers to jail to force them to comply. However, there is a catch. To actually send a lawyer to jail for criminal contempt, the Justice Department would have to prosecute them. And as the sources point out, the Justice Department is part of the administration. It is very unlikely they will prosecute their own people for carrying out the administration's policies. This leaves the judges in a bind. They can threaten, they can sanction, they can shame, but they don't have their own police force to go out and make arrests. They depend on the executive branch to follow the rules. This is the stress test we are watching in real time. Can the legal system actually hold a president accountable if he and his lawyers decide they don't want to play by the rules? So where does this leave us? We have seen a man like Kilmar Abrego Garcia become a top priority for prosecution because he won a court case. We have seen law firms targeted with executive orders because they once worked on the Mueller investigation. We have seen lawyers like Alina Habba have their appointments declared illegal by federal judges. And we have seen a massive wave of litigation over everything from birthright citizenship to DEI initiatives. The sources suggest that we might not see a dramatic resolution anytime soon. There won't be a single moment where everything is fixed. Instead, we are building a long-term historical record. Every time a judge issues a scathing opinion calling out misconduct, it becomes part of the permanent record of our time. Every time a lawyer is sanctioned or a policy is found illegal, it is documented for history. This might feel unsatisfying to people who want to see consequences now. But the legal system moves slowly. It is deliberate, it is procedural, it is often boring, but it is the only system we have to ensure that the law is a shield for the citizen and not just a sword for the government. The real story isn't the clickbait headline about an immediate arrest. The real story is the daily struggle in courtrooms across the country to maintain judicial independence. It is about judges like the one in Maryland or the one in Nashville who are willing to draw a line and say, no, you cannot do this. Even if you are the government, you have to follow the law. As we watch these cases move forward, from the DOJ data fights to the vindictive prosecution hearings, we are watching the most significant legal battle in American history. It is a battle for the soul of the justice system itself. It is a question of whether the law still applies to everyone equally, or if it has truly become a tool for the powerful to reward their friends and punish their enemies. It is important to remember that all of these developments, the unsealed emails, the illegal appointments, the sanctions against lawyers, are not based on rumors or political opinions. They are based on court filings, unsealed orders, and the testimony of officials. When we talk about the weaponization of the DOJ, we are looking at the specific email from Akash Singh that called a retaliatory case a top priority. When we talk about the decline in the quality of the president's legal team, we are looking at the disbarment records of Rudy Giuliani and the sanctions against Sidney Powell. When we talk about the administration's defiance of the law, We are looking at the analysis that shows they have ignored 1/3 of the court orders against them. The facts are there. They are documented in thousands of pages of court records. They show an administration that is testing every boundary of the law and a judiciary that is struggling to hold the line. It is a story of conflict, but it is also a story of resilience. Because as long as there are judges who are willing to unseal these orders, and as long as there are lawyers who are willing to fight for people like Mr. Abrego Garcia, the system is still working, even if it is under immense pressure. The crisis of trust we talked about, the skepticism of Gen Z and the suspicion of institutions, is a direct result of these conflicts. When people see the law being used for retaliation, they stop believing in the law. That is a heavy price to pay for a political victory. And it is something that will take years, maybe decades, to repair. But for now, the fight continues in the courtrooms. The appeals are being filed, the testimony is being taken, and the judges are making their rulings. It is a slow, grinding process, but it is the most important process in the country. Because in the end, the only thing that separates a democracy from something else is the rule of law. And the rule of law only survives if it is defended, case by case, ruling by ruling, and fact by fact. As we move deeper into this second Trump presidency, the strategy is becoming clear. It is a strategy of aggressive testing. The administration is pushing a wide range of policies that they know will be challenged in court. They are moving birthright citizenship to the Supreme Court. They are dismantling federal agencies through executive orders. They are using DOJ to bypass traditional congressional oversight. By filing so many orders and making so many changes at once, they are overwhelming the legal system. There are simply too many cases for any one judge or any one organization to track. This creates a fog of litigation where the administration can move forward with its agenda even as the courts are still trying to figure out if it's legal. But as the sources show, the courts are adapting. They are starting to consolidate cases. They are moving faster on injunctions. And they are becoming much less patient with the delay and obstruct tactics that worked in the past. The judiciary is learning how to handle a president who views the law as an obstacle to be overcome rather than a set of rules to be followed. This is a high-stakes game for both sides. If the administration succeeds in bypassing the courts, it will have successfully reshaped the American government into a much more powerful and centralized executive. But if the courts succeed in holding the line, they will have reaffirmed the principle that no one is above the law, not even the president. The case of Kilmar Abrego Garcia is still ongoing. The hearing for his motion to dismiss based on vindictive prosecution has not happened yet. But the unsealing of that order was a major moment. It sent a message to the DOJ that they cannot hide their motivations behind attorney-client privilege when those motivations might be illegal. It reminds us that the top priority of the law should always be justice, not retaliation. It reminds us that every citizen has the right to win in court without becoming a target of the government. And it reminds us that even in a time of extreme political division and institutional distrust, there are still places where the truth can be unsealed and the facts can be heard. We will continue to watch these cases, the DOJ lawsuits, the Haba appeal, the Corcoran testimony, because they are the chapters of the story we are living through. It is a complex story, and it doesn't fit into a 10-word clickbait headline, but it is a story that matters for the future of the country. The legal battles around Donald Trump are real. The tensions are real, the warnings are real, and as we have seen tonight, the consequences are starting to become real too. Whether it's a lawyer losing their license or a top priority prosecution being exposed, the machinery of justice is moving. It is slow, but it is moving. And in the end, that is what matters most. Imagine the American legal system is like a massive dam holding back a river of political power. In a normal season, the water level is steady and the dam works quietly. But right now, the water is rising fast and people are trying to drill holes in the concrete to let the power flow where they want it. The judges are like the engineers rushing to patch the cracks and keep the structure standing. They don't have enough tools for every leak and the pressure is higher than it's ever been. But as long as they keep patching, the system stays dry. If the patches fail, the river of power overflows and the rules we all live by get washed away.